This hearing may be labeled post-case, but what unfolds is anything but routine. Within minutes, the courtroom shifts from procedural housekeeping into a serious legal crisis that puts the defendant's freedom directly on the line. At the center of it all is Larry Lee, a defendant who, according to the prosecution, didn't just make a bad decision, but may have crossed into one of the most dangerous territories in criminal law, interfering with witness testimony. We're talking about recorded phone calls, alleged back-channel negotiations, and a claim that testimony in one case was being traded for silence in another. That's not strategy, that's potential obstruction. And when a judge hears words like exchange, not testify, and recording, alarms go off immediately. What makes this case even more volatile is that the defendant isn't silent. He speaks at length. He names legal standards, references Strickland v. Washington, and claims he recorded calls to prove his own attorney was ineffective. The question is, does that explanation save him or bury him? Stick with this one, because by the end of this hearing, the judge makes it clear some lines, once crossed, change everything.
To an exchange, there's a pending case where Mr. Kwasny is the defendant of an AMD against Mr. Lee. Mr. Lee contacted Mr. Rabo and offered to essentially not testify in that case if Mr. Kwasny agreed not to testify in this case. There are statements that are essentially saying, in exchange for Mr. Kwasny, victim in this case, not testifying, I will also not testify. That is highly concerning, of course. I was given this information yesterday. I asked Mr. Arabo to forward that call to myself, Mr. Burgess, and the officer in charge because we want it documented for potential additional charges. But this all transpired yesterday. We got the recording as of this morning. With that said, of course, I think it's appropriate to have an adjournment. Mr. Burgess agrees with that.
But does that recording indicate that?
Yes, Your Honor. Have either one of you listened?
I myself have not listened to the recording. I was just asked to stand in on behalf of Mr. Burgess. He's at a hearing in Lansing. However, I did speak to Mr. Lee about—
This is where the case takes a sharp and dangerous turn. The prosecutor isn't alleging a misunderstanding. She's describing conduct that could qualify as witness tampering. The concern is simple but severe. The defendant allegedly contacted opposing counsel and proposed that neither side testify against the other in their respective cases. In plain terms, that's not negotiation through attorneys. That's direct interference. Legally, this matters because witnesses are not bargaining chips. Any attempt to influence testimony outside proper legal channels can result in new criminal charges separate from the original case. That's why the prosecution immediately asks for the call to be preserved, forwarded, and documented. This isn't about scheduling anymore. It's about evidence. Notice the judge's reaction here. The questions aren't casual. They're pointed. The court is trying to determine whether this was reckless speech, intentional manipulation, or something even more serious. And once the phrase potential additional charges enters the record, the stakes skyrocket. Viewer question: if you were facing charges, would you ever risk making a call like this yourself?
Seems to feel that he needed to make that phone call because he wants to move to have Mr. Burgess removed and he wants to get a different attorney. Mr. Lee has indicated to me he also wants to address the court. I again did advise him I would not go into the content of that conversation as there could be potential pending new charges. With that said, Mr. Lee, what is it you wanted to say?
Yes, Judge. I indicated to, what's your name?
Ms. Rubio.
To Ms. Rubio that for a little bit over a month, I contacted my attorney, Mr. Burgess, and I instructed him to contact the lawyers from both sides, the prosecution and the other side that represented Mr. Kwasny, and I instructed him to offer a plea or to negotiate some sort of settlement, and he indicated that he would do that. He indicated that he had done that. He indicated that he had reached out to Mr. Arabo and the prosecutor regarding making some sort of plea agreement. Him and I discussed what that could be. And so now, fast forward, yesterday, I contacted Mr. Burgess and I said, hey, have you reached out or have you heard anything from Mr. Arabo and the prosecutor? He said, and he indicated.
This is the moment where Larry Lee takes control of the narrative and possibly loses control of the outcome. He explains that he recorded the call himself, not to interfere with testimony, but to prove his attorney was ineffective. He references Strickland v. Washington, the legal standard for ineffective assistance of counsel, and claims he needed evidence to justify removing his lawyer. Here's the problem. Even if his motive was to document attorney failures, the method still matters. Recording a call in which testimony is discussed, especially with language suggesting an exchange, creates exposure regardless of intent. Courts don't just analyze why you did something. They analyze what you actually did. You can feel the tension rise as the judge repeatedly stops the explanation. The interruptions signal concern, not confusion. When a judge cuts someone off mid-statement, it often means the explanation isn't helping. It's hurting. This is a classic courtroom moment where speaking more doesn't equal clarifying more.
Communications with my attorney. So I confirmed with Mr. Arabo that he had not received any communications about any kind of negotiations with any kind of plea agreements on my behalf.
I'm so sorry to interrupt Mr. Lee before he makes more statements.
And I did record the
that are false to this.
I recorded the call.
Criminalizing himself.
I recorded the call.
In his best interest, he might want to listen to this call before he makes any further statements. In the call that was sent to us, there is indication there's no discussion of a plea, not what was sent to me. That was recorded by Mr. Arabo. There's very clear that there will be no testimony in his case if Mr. Consley agrees not to testify in this case.
So I have the text messages.
Further false statements are made to the court, which is not necessarily a problem for me, but I want to make sure that Mr. Lee's rights are preserved.
I have the text
He
messages.
might want to listen.
You don't know what? That's the third time you've done it. You're gone. Mr. Allen, take him. You better get Mr. Burgess down here because I want to hear those calls because if he's interfered with it, that's going to be a whole other issue.
I will try to reach
The
him.
judge's conclusion is clear and devastating. What the court is hearing is extremely disturbing, and that concern translates directly into action. The judge states on the record that he is inclined to revoke bond and hold the defendant in custody. That's not a final trial verdict, but it is an immediate loss of freedom based on risk, credibility, and conduct. The broader takeaway here is critical. Bond is built on trust. Once a court believes a defendant may interfere with witnesses, that trust evaporates. Even unresolved allegations can justify dissension if the court believes the integrity of the process is at risk. This case is a textbook example of how quickly a situation can escalate when defendants take matters into their own hands, especially outside the guidance of counsel. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.